Good morning, everybody. I would like to call to order meeting number 29 of the Standing Committee on Human Resources, Skills and Social Development and the Status of Persons with Disabilities, and further to our study on Bill C-31, an act to amend the Old Age Security Act. We're very pleased to welcome our Minister, the Honourable Diane Findlay, with us this morning, as well as officials from the department. Welcome. Thank you so much for being here. We look forward to hearing from you and then going around the table and asking you some questions. So, Minister, at this time I will turn the podium over to you. You have 10 minutes, and if you'd like, I could give you a 1-minute warning when you're close to your 10 minutes.
Okay.
All right. Thank you.
Thank you very much, Madam Chair. Good morning. Bonjour. I am really very pleased to be here to discuss Bill C-31, the Eliminating Entitlements for Prisoners Act. Canadians were shocked and outraged when it was discovered that mass murderers like Clifford Olson, who admitted to brutally killing 18 children, are receiving old age security and guaranteed income supplement benefits. In a few short years, Paul Bernardo is supposed to receive these benefits, as are Robert Picton and Russell Williams. This not only angers Canadians, but it's also outrageous and offensive to myself, to the Prime Minister, and to our government. Which is why, as soon as we discovered this practice, our Conservative government took immediate action and introduced Bill C-31, which puts a stop to incarcerated criminals receiving these benefits. Madame la Présidente, le programme de la sécurité.
Madam Chair, the purpose of old age security is to help seniors, especially those living on a fixed income, meet their immediate day-to-day basic needs, and to maintain a minimum standard of living in their retirement. This is in recognition of the contributions that seniors have made to Canadian society, to our economy, and to our communities.
Needs such as food and shelter are already met and paid for by tax dollars contributed by hardworking Canadians. Canadians accept these costs because they want to make sure that criminals stay off the streets and stay in jail where they belong. But what Canadians and our government will not accept are benefits meant for law-abiding, hardworking seniors going to incarcerated criminals. The OAS program is not a savings plan for prisoners in which they accumulate tax dollars for their own personal use off the back of hard-working taxpayers. Since an inmate's needs and the basic needs are already met by public funds, Canadian taxpayers should not also be paying for income support through OAS benefits. It's grossly unfair to make law-abiding Canadian taxpayers pay twice for incarcerated criminals. In short, Madam Chair, whether someone is in jail for 3 months or 30 years, the fact is that taxpayers are already footing the bill for their room and board. So convicted criminals should not be receiving old age security benefits that are intended to help seniors pay for their basic expenses. Accordingly, Bill C-31 puts an end to criminals receiving OAS and GIS benefits while in prison. It aims to do this in 2 steps. First, once the bill is passed, it would terminate OAS benefits for prisoners sentenced to more than 2 years in a federal penitentiary. This would affect approximately 400 inmates and save Canadian taxpayers approximately $2 million. The federal government would then work with provinces and territories to sign information sharing agreements to proceed with the termination of these benefits for incarcerated criminals serving 90 days or more in a provincial or territorial prison. This would affect about 600 provincial and territorial inmates per year and result in savings to taxpayers of an additional $8 million annually for a total of $10 million per year if all provinces and territories sign on. Bill C-31 is in line with what several provinces are already doing. In fact, British Columbia, Alberta, Saskatchewan, Ontario, Quebec, New Brunswick, Nova Scotia, and the Northwest Territories already do not pay social or income assistance to incarcerated criminals. I personally wrote to all the provincial and territorial ministers to ask for their support and cooperation in signing information sharing agreements once our bill is passed. And I commend British Columbia, Alberta, Saskatchewan, Manitoba, Ontario, and Newfoundland and Labrador for informing me that they support Bill C-31 and will work with our government to get an agreement signed as quickly as possible. Madame la Présidente, j'estime.
Madam Chair, I feel that it is important to note that we have been very careful to ensure that innocent spouses and common law partners do not suffer as a result of the actions of their spouse. These innocent individuals will not lose their individual entitlement to the guaranteed income supplement and the allowances as a result of these proposed amendments. They will still receive benefits based on their individual income rather than the combined income of the couple. Bill C-31 is yet another example of our Conservative government ensuring fairness for hard-working taxpayers. It is yet another example of our government putting victims ahead of criminals.
This bill is doing what is right and what is fair. Our government believes that Canadians who work hard, who contribute to the system and play by the rules, deserve benefits such as OAS. Prisoners do not. The proof that this bill is the right thing to do can be found in the truly overwhelming support that we've received for it. In fact, I've probably received more correspondence on this issue than any other. One of the people that touched me the most was a mother whose life was forever altered by Clifford Olson after he brutally murdered her son. Her name is Sharon Rosenfeld, and she is the president of Victims for Violence. When I introduced this bill in the House, she said, and I quote, "I commend the Prime Minister and the Minister for taking leadership on this important issue and ending entitlements for convicted criminals. It's great to see that this government is putting victims and taxpayers first, ahead of criminals. The suspension of OAS benefit payments to inmates does just that," end quote. Ray King is another parent whose life was forever changed by Clifford Olson's heinous crimes. When he heard that this bill had been introduced, he remarked, "It's the best news I've heard in a long time. I'm quite pleased that the government has done something." These two individuals are part of a long list of people which also includes David Toner, the president of Families Against Crime and Trauma, and Vancouver Police Chief Jim Chu, who support Bill C-31. These, ladies and gentlemen, are people who fight for victims and hardworking, law-abiding Canadians and agree that this bill must be passed. But what has had an equally large impact on me has been the number of everyday Canadians who took the time out of their busy schedules to express their opinions. In just a few short weeks, 50,000 Canadians signed a petition by the Canadian Taxpayers Federation in support of this bill, and many Canadians have written to me personally or to their local member of Parliament. When I first spoke on this bill, I provided a small sample of what Canadians have been saying. And there are far too many citations to list them all here, but I want to provide a few more examples so that the members of this committee can understand just how strongly Canadians support this legislation. From Redvers, Saskatchewan, quote, "The taxpayers of this country are providing room, board, and medical care for these people who have chosen to disregard the rules of our justice system and the rights of those they have acted against. We should not be providing pensions." From Kingston, Ontario, quote, "I am very annoyed that Clifford Olson, a convicted notorious killer, is receiving Canada's old age pension. I am really, really angry about this and want you to change the law." From Fredericton, New Brunswick, quote, "You are right. Prisoners receiving old age security benefits is an insult to his victims and to all Canadians." From Vancouver, BC, "Thank you so much for promptly saying that you will ensure that prisoners will not receive OAS. I've always appreciated your government's actions to improve social security programs in a responsible manner that considers taxpayers as well as recipients." Madam Chair, Canadians across this great country agree. Ending entitlements to prisoners is the fair and right thing to do, and they want Bill C-31 passed into law. Canadians know that our Conservative government will always stand up for law-abiding, hard-working Canadians and for their families. They know that we will use their hard-earned tax dollars fairly, responsibly, and prudently. Bill C-31 is about the responsible use of public funds and the fair treatment of taxpayers. We're taking action to put an end to entitlements for prisoners and to ensure that those Canadians who have spent their lives working hard and playing by the rules receive the benefits that they deserve. I hope that all the members of this committee will stand up for hard-working, law-abiding Canadians, stand up for what is right and fair, and support Bill C-31. Merci, thank you, and I'd be happy now to answer your questions.
Thank you very much, Minister Findlay. We will begin with our first round of questions. Just a reminder, the first round is 7 minutes, and that includes questions and answers. And we will begin with the Liberals with Mr. Savage, please. Thank
you. Minister, thank you for coming. It's always wonderful to have you here with the committee. I think you know that all parties have indicated support for this, and that we were all concerned when we found out that there was a loophole in the system that allowed people like Clifford Olson to get these benefits. In fact, our critic, Judy Scrow, had indicated support from the very beginning. I think we could have moved it through to the committee even faster than it eventually came. But we also want to make sure that there are some people who are not Clifford Olsons who may have families or dependents, and I know that my colleague Ms. Minna has some questions about that. But nonetheless, we think we need to move this along. I want to ask you, you referenced in your comments the provinces, those who have signed on to this. There are some provinces who haven't, and I wonder what action you're taking to convince them, and perhaps tell us what their concerns are with C-31.
Well, there are, as I mentioned, several who have signed on already. I'm very pleased about that. There are, after all, 8 provinces who have this in practice already, provinces and territories, who practice this with their own provincial social assurance programs. We're working with the provinces. We're encouraging them to join us in this effort, and there are discussions going on at the political and at the officials levels to encourage them and address any concerns that they may have.
What are those concerns? What are the issues that they're saying? What are they telling you that they have concerns about that prevent them from signing on now?
Well, first of all, a lot of them want to make sure before they sign on that the law does pass. They don't want to spend a lot of time saying what if, what if. Some of them have limited capacity to adapt to new programs that may not exist. And so they want to make sure, in many cases, that the bill is passed first.
Do you expect that all will sign on?
I'm very hopeful that they will, because it is the right thing to do. And Canadians right across the country have written to us by the thousands indicating that this is what they believe to be right and fair.
One of the questions that we've had is that this bill will save somewhere between $2 million and conceivably up to $8 or $10 million a year. And it has been raised, and we've raised this ourselves. Why not dedicate that money to victims of violence groups if you're saving it? This is about doing the right thing, and there's a corollary benefit of saving taxpayers' money. Why wouldn't we dedicate that to victims of crime organizations?
Well, the OAS program, Old Age Security, is a statutory program, and within the Act it says that those funds are to be used solely for the support of seniors and to provide their basic benefits. Our government has done a lot to help victims. We've set up special victims funds, ombudsman. Some $50 million is being invested over a period of, I believe, 4 years. This bill deals exclusively with ending the entitlements. Any other use of funds would be more appropriately addressed in another bill, because we are respecting the statutory nature of the OAS funds that are provided through the general revenue.
No, I understand that, and I don't want to be combative here. We're largely on the same page on this, but it just seems to me that, you know, it's been done before where governments have made initiatives that balanced off one thing against the other. Because it's not from the same revenue stream or payment stream doesn't mean that one couldn't say, let's make sure that we take that and put it toward victims of crime. I just wonder if that's something that you might consider going forward as a government.
Well, at this point, my primary concern is getting this bill passed to end the payments that are currently existing. That is the number one priority. In terms of support for victims, we are providing quite a bit through a number of different programs. But again, I go back to the fact that OAS is a statutory program, and according to the law as it stands right now, the funds from OAS must go to the support of seniors only.
I just want to ask you another question. People who are on employment insurance cannot collect benefits while they're incarcerated. Is that correct?
By and large, that's the rule, yes.
By and large?
There are obviously going to be certain exceptions.
Well, Section 37 of the EI Act indicates that a claimant is not entitled to receive benefits for any period during which they're an inmate in a prison or similar institution. I just wonder if you've done any work in your department to ensure that there aren't prisoners who are receiving employment insurance who shouldn't be receiving it. Are we going to hear another story in a year or so about somebody, an egregious criminal who's collecting employment insurance?
I think there are two very big differences here. Number one is that, according to the law as it stands, prisoners are entitled to receive OAS while they're in prison. They're not entitled by law to receive EI.
Right.
We do have a rigorous and very robust audit system within EI to make sure that anyone, wherever they are, whatever their circumstance, if they are abusing the system, claiming funds, EI benefits fraudulently, that they will be dealt with according to the law.
Yeah. So you have taken it upon yourself to ensure that there's nobody collecting EI who's in prison.
That's part of the rules, and the rules that we enforce through a very rigorous control system at EI.
Okay. All right. Thank you for that. In terms of the resumption of benefits, so when somebody becomes incarcerated for a period long enough to qualify under this legislation, they automatically would stop getting their benefits. When they come out, they have to notify Service Canada so they can resume their benefits. Will there be some provision that while people are in prison in their last month or 2 months that would assist those people, particularly those who might hit the streets without anything, to make sure that they do resume the benefits, to make them aware of their rights to resume benefits?
Well, we will be notifying them. We're putting together all the details of the implementation. We can't be too presumptuous about the bill passing, but we are looking at those sort of circumstances. One of the things that we can do is, well, first of all, once we have all the necessary agreements in place with the provinces to make it complete, what we can do is have the institution, the incarcerating institution, notify us. They would report on a monthly basis who's being released with the information that they have.
Okay.
Then it would
so
be
that will happen, Minister? That
would be part of the process.
Because initially the legislation requires the prisoner to notify Service Canada, but there will be something put into the system to assist in...
It's a two-part system. Number one, the institution who's releasing the individual would notify Service Canada so we can activate the file, but the individual is also going to have to contact us primarily so that we can get the appropriate banking information to make sure that they do get the funds to which they're entitled.
Thank you very much. Monsieur Lessard?
Thank you, Madam Chair, and thank you, Minister, for being here with us this morning, as well as your officials. Minister, along the same lines as the questions already asked by my colleague, I would like to know what the consequences are for the provinces. In what sense? Well, are there consequences? For example, if a province decides not to participate under C31, will there be consequences for the province? I hope that all provinces and territories will participate. That is my great hope. But are there consequences? I don't know if all provinces will take part. In all provinces, there are people who support this bill. That isn't my question. My question is whether you have looked at whether there are consequences for the provinces. If you haven't looked into that, then that's no problem. It would be up to each province and territory to decide whether to participate or not. There will not be any direct consequences by the government. Minister? You are no doubt aware that Section 78 under the CCRA already states that 30% of an inmate's income can be withheld to cover lodging costs. Do you know how many people right now, how many inmates who have been affected by that measure? I don't have the exact number, but I believe that the Commissioner of Corrections Canada has already answered that question. There is a maximum of $25 a week that they can receive. So 30% of their personal income, I believe. But up to a maximum of $25 a week. The legislation talks about 30% of their personal income, I believe. I will just repeat what the Commissioner mentioned because I think it is very useful. There are special conditions for this money to be withheld, and this only applies to accounts that are within the institution, and there is no control over outside accounts that the institution is not informed of. So Section 78 was not an appropriate alternative for this issue. Well, where I was going with that is to ask whether you have looked into another matter. We agree with this bill. We support it. But did you look into the possibility that I mentioned, and I asked the Commissioner this, who said that it was a political decision. There could also be an amendment to Section 78 of the CCRA. Did you look into that possibility? We looked for a number of possible ways of resolving this problem, but the best way is through Bill C-31. This is the most comprehensive and direct way, so it's the best way of approaching this. So you didn't look into the other possibility. One witness who came before us raised this, and we looked at this ourselves, and we felt that there was potential there. That is, to give the Commissioner the permission to go beyond the 30% or the $25, and it would be just a matter of amending Section 78 of the Corrections and Conditional Release Act. To answer your question, yes, we looked into the issue with Correctional Services Canada, and our conclusion was that even if we amended Section 78, it would not achieve the same result as this legislation because, as the Commissioner indicated, they have access only to accounts within the institution, and any money that is deposited in outside accounts is outside the mandate of Section 78. And therefore, we concluded that the only possible and the best approach was to have new legislation, because even if we amended the section under the other act, it wouldn't help. How many inmates receive the OAS? This was something, and who have children. Do you know? 400 in federal institutions and 600 provincial and territorial inmates who are 65 or over. How many children these inmates might have under the age of 18 is not something we know. We don't have any way of getting that information. But the challenge here is to recognize the purpose of the old age security system. It is not intended to support families, but rather seniors. There are a number of other programs that support children, We are obviously concerned about the well-being of families and children, but this program is aimed at supporting seniors and providing them with a basic standard of living. But Bill C-31 does contain provisions, for example, for dependents. And one way of solving this issue is that if someone is in prison, then there could be this assistance. If you have no information and if the benefits have been provided for more than 1 month, will there be a reimbursement either by the inmate or by the spouse? I'm not quite clear about your question. So if there has been an overpayment, all of the rules already in place for old age security will be applied. So if there is an overpayment, then that will be dealt with as quickly as possible.
Paul Martin now, please.
Thanks, Madam Chair. Thanks, Mr. Minister, Madam Ministers, and the rest of the witnesses for being here. Just following up on Mr. Lassard's question, we heard from Commissioner Head that the, and I think this was universal, I don't think there was any exceptions, that they always know at least a month in advance of when a prisoner is going to be released. The way you've worded Section 5, it only allows the prisoner, or I guess now ex-prisoner, to notify you, the minister, once they've been released. That's the way the tense of the verbs are in that section. Would you be open to an amendment that would allow them to notify the minister at the time that they became aware of their date of release?
I think one of the key things here is that a lot can happen in a month, and we want to make sure that the entitlement resumes once they are released. If, for example, someone were to apply a month before their release and 2 weeks later do something that would prevent their release, then we would be going through with the administration. We wouldn't know where they were, that they hadn't been released, and we would get into a situation where we conceivably could be paying them even though they haven't been released.
But you've got to double check on that, because the Commissioner's office is going to send you on a monthly basis people who in fact are going to be released. It would be very simple for them to be on that monthly statement to be advising you if the situation has changed. There's no particular problem with doing that. Well, that's I'm sorry, Madam Minister, for interrupting, but Mr. Head made it quite clear that that's a computerized system, so it's quite easy to make the adjustment. And we're talking very few on a monthly basis notifications. Maybe some months where there'll be no releases at all. So it's quite easy to do it. And let me just make this point so you understand what and I think other members of the committee share this concern. What's going to happen if the release is notified to you the month that they're released? We're going to have people on the street over 65, probably incarcerated for a long period of time, totally unemployable, both because of age and because of the criminal record, and no funds at all other than the $80 that they get out of prison. High rate of reincarceration as a result of that, or they go to municipal welfare rolls, and that's not fair to the municipalities or the provinces. So that's our concern, and it seems to me that that type of an amendment, which would allow the notification to come at the time that the prisoner is aware of it, would resolve those concerns.
Well, and we do share concern about when they are released, and quite frankly, you point out that the numbers would be very low. Service Canada would be administering the OAS as they do now, and there is provision within Service Canada that they can write an expedited check under unusual circumstances. So if someone were released, say, Monday, went onto Service Canada, filed the information, as I say, primarily the banking information so that we could confirm it. As soon as it's confirmed with the institution, we can issue a special check on very, very short notice. So they don't have to wait an entire month to receive their benefit. That's something we have already contemplated in the implementation.
This is no reflection, negative reflection on the staff in your department, but you know, after 10 years here, I can tell you I don't have a lot of hope that that is going to be done efficiently, simply because you don't have enough staff to do it efficiently. But I'll leave that. I want to go to another point, and that's the issue of the what is almost certainly an inevitable charter challenge to this legislation. When has the department get a legal opinion, and if so, are you prepared to share that with us?
Well, one of the things that's important to recognize is that we do believe, our government does believe that this is legitimate, it is constitutional. OAS already has several conditions. It's not a universal program. There are conditions required to receive it. There's a residency requirement, there's an age requirement, and there's even income testing to determine what level. GIS is income tested. So there are already conditions on that, but we do have government opinion. We always, before we table legislation, we run it past the lawyers, and they do believe that this is legitimate. Did you want to add anything, Mark? Introduce yourself.
Mark McCombs, I'm Head of Legal Services, HRSDC, Department of Justice. From the Department of Justice perspective, we're satisfied the legislation is constitutional and is consistent with the Charter. We've got a requirement under the Department of Justice Act to state if it is not, and we have certified that it is. So from that perspective, in terms of Charter litigation, that would be speculative at this point.
I'm sorry, the opinion didn't take into account the Charter?
No, under the Department of Justice legislation, Section 4.1, the Minister of Justice is required to examine all legislation and determine if it consistent with the Charter, and in the event that it isn't, we have to report this to the House. And we have not reported it to the House, and the Minister is quite clear that we've determined it's constitutional.
McComb?
Yes.
If I could just ask you, when you speak, we're getting some feedback, and I think it's because your earpiece is close to the microphone, so if you could just sit back a little.
Sure.
Thank you very much.
Or take my earpiece off.
That would be good, too. Thanks.
I don't have enough time to argue this with you, so I'm going to move on. Let me just raise this one point. Madam Minister, you pointed out that the existing legislation does have conditions on it for everyone, age, citizenship, residency. I think all those are conditions that applied to the right to vote, but the Supreme Court of Canada determined that prisoners had a right to vote.
Citizenship requirement.
I'm sorry. I was saying that was a condition for the right to vote.
Oh, okay. Sorry.
You know, there was conditions in there as well, perhaps more onerous than there is here. And in that situation, under the equality sections of the Charter, they found that the prisoners had the right to vote. Anyway, we're going to get into a legal argument here.
And Mr. Kilmartin, your time has expired.
I have so much more.
Well, you probably will get a chance if we get through. You might get another round. We'll go to Mr. Kilmartin.
Thank you, Madam Chair, and welcome, Minister. Certainly the title, I think, of the legislation, Ending Entitlements to Prisoners, is a good one. And I was pleased to see that you had in your speak notes from a constituent of mine, Ridver, Saskatchewan, because I think that quote captures the essence of this bill. It states the taxpayers of this country are providing room, board, and medical care for these people who have chosen to disregard the rules of our justice system and the rights of those they have acted against. And I know the members of the opposition have referred to Section 78, and it's a somewhat cumbersome section, and if it worked at its best, it would take $25 a week or $100 a month away from the OAS or GIS, which wouldn't be very much, and the rest, I suppose, would go into the account. So in your view, I would take it that that doesn't address what we're trying to do with this bill, the Section 78.
You're absolutely right. If an institution were to deduct $100 a month, basically $25 a week, that would have, first of all, they'd have trouble accessing those funds, so it becomes extremely problematic. Secondly, it doesn't end the fact that prisoners who have been convicted criminals would be receiving the old age security benefit that was intended to ensure that Canadians in their senior years would have a certain standard of living, that they would be able to take care of room, board, house and feed themselves. These benefits are already received at taxpayers' expense by prisoners. They're getting their room, they're getting their board. We believe that these prisoners should not be getting paid twice.
That's precisely the point of the correspondence there. And I know we've heard from Sharon Rosenfeld, whose life has been forever changed by Clifford Olson after he murdered her son. I can't imagine how she must have felt knowing that he was also receiving old age security and other benefits. And David Toner, you had mentioned that he was in support of this legislation. He's the president of Families Against Crime and Trauma, and he said, "We're thrilled that the Prime Minister and the Minister have taken leadership and are putting victims ahead of entitlements of prisoners." And I know Mr. Cole-Martin was talking about, what about the prisoner and what about having funds available for them. I think that David Toner sort of captures that as well, that there is the issue of the victims as opposed to just entitlements of prisoners. And would you comment on that?
Well, really, that's a lot of what this is about, is that we brought in a lot of programs to assist victims and their families, through the Ombudsman, the funds. There's a long list of things, investments that we're making to help support and protect victims. But when it comes to the criminals themselves, I think they're in prison because they have broken our laws. They have violated our standards of what is decent living in Canada, and so they're in prison. They're there to pay their debt to society. We believe that they should not be getting paid by society as well.
It's a fair point, and I have a quote here from the Vancouver Police Chief Jim Chu in his news release of June 2nd, 2010, and he said, "It would be my hope that innocent victims will no longer feel further victimized by watching their attackers receive old age pension during their forced retirement from their careers of crime." And so that also addresses that. But many have expressed a concern, what about the spouses of prisoners? Are they going to suffer because of this legislation? And perhaps you could comment on that and how administratively that concern can be addressed.
Well, we don't believe that the innocent spouses or common law partners of convicted criminals should suffer financially because of the deeds. These individuals are innocent. They would retain any entitlement to the old age security benefits, to the guaranteed income supplement, or even to the allowance. But they would do so not based on the couple's income, but on their own individual income. So what we make sure is that the spouses, the common law partners of convicted criminals would retain their entitlement. They still would receive their old age security benefits and their guaranteed income supplement benefits. They shouldn't be victimized by the deeds of their spouse.
Fair point. And then I note that there's always that issue of constitutionality raised by, I know at least Mr. Cole-Martin does, but just to be clear, the old age security and GIS entitlements by prisoners is not taken away forever. It's simply suspended during the time that they're incarcerated, paying their debt to society. And you might want to comment on that. And are we the only country that is doing what we're doing in this bill, or might there be others?
Well, it is something that's fundamental to your belief system. If someone is paying their debt to society, should you be paying them on top? Right here within Canada, without having to even look abroad, 8 of our provinces and territories already deny social assurance, social security benefits, and such to incarcerated prisoners within their provincial or territorial judicial system. If we look further abroad, you look at the United Kingdom, you look at the United States, you look at Australia, they all have similar provisions at the national level. They too believe that society should not be supporting individuals by trying to provide by providing for their basic needs in terms of housing, shelter, and food, and then paying them on top of that through an old age security system that's designed to help those who are in need and who are looking to achieve a particular, a certain level of standard of living in their golden years. These are people who have contributed to our country. They've been law-abiding systems. Yes, we're there to support them, but those who have violated our code of standards and have been convicted of that, no, we don't think so. And several other countries agree with us, as do most of the provinces and territories.
Thank you, Minister.
Thank you. We will begin our second round of questions, and this will be a 5-minute round. And I do realize, Minister, that you need to go at about quarter to the hour. So we'll begin with 5 minutes with Madame Mina, please.
Thank you, Madam Chair. I'll be sharing some of my time with Madam Folco, if I may. Minister, I just I have one question very briefly. I had this discussion with the officials when they were here, and my question is that when your department, or just as I imagine your department was involved, and as you are the Minister responsible for old age security and for families, actually, so this works really well, did your department ask for information on the families, on the inmates? Not only how many were there, how many were married, and how many of them would have had dependent children or other dependents besides spouses?
Until we sign work-sharing agreements with the provinces, we have no idea of knowing even exactly how many prisoners there are. We do have an estimate of about 600 that would be affected by this. We certainly don't know any of the details. And in drafting the bill from the federal perspective, we do not have that information at this point in time, no. I would expect, however, that given the fact that you have to be 65 years old to qualify for old age security, that there wouldn't be a whole lot of cases where there would be a dependent minor.
The reality, though, is, Madam Minister, that there are people who have children, maybe in their teens, when they're 65, who are still going to university or school, or others who might be dependent. I just find it rather odd, to say the least, that a department is responsible for families would not have that information or make sure they had the information. There have been months while the bill was being drafted, at least the 400 that apparently are in our national federal system, that information could have been collected. I've asked for that to be done from the officials that were here before, but I would advise that we do that, because there could be unintended consequences that the bill would have. And I'm not saying that, and obviously the bill is moving forward and we are supporting it, but we also want to make sure that, as you say in your own remarks, that people who are innocent people are not in any way affected negatively because of something we're doing. So I would hope that that information would be looked at as quickly as possible. And then I don't know what we do with this in terms of, since the bill will have passed by the time the information is gathered.
Well, there are a number of programs, as I believe you're aware, that do address the needs of dependent minors, whether they're, that are income tested, so that if the family income does drop, they become eligible for a lot more benefits. A simple example would be the Canada Student Grants Program, which is income geared to assist students by providing grants to them, monthly grants for post-secondary education that go up as the family income goes down. These are grants so that these students aren't incurring debt.
I'm sorry, Madam Minister, but my colleague needs to come, but I'm talking about people who may not be in university but dependent children. And it's not just a matter of pension, it's a matter also of grants. It's a matter of day-to-day survival. I'll just let my colleague go on, because otherwise we won't be able to get her in.
How much time do I have, Manager? Okay. Well, la question se pose par exemple.
I have a question that follows up on my colleague. That is, this affects not only people who have children in university, but what about disabled children who may be dependent on parents, on the person who is an inmate, and may be dependents throughout their lives? So the question that I asked Corrections Canada 2 days ago, I was told by them that they didn't have information on how many inmates had dependents. The next step would be to find out why, and if there is a good reason, Ms. Mina and I have discussed this, we would strongly suggest that that question be asked of the inmate as soon as the person arrives, and that information should be collected so that it can be made available. And after all, we already asked whether there is a spouse, so why not ask about dependents?
We're mixing different issues here. We obviously are concerned about dependent children, whether they're in university, as Ms. Minna originally suggested, which is why I cited the Canada Student Grants Program. But we do have a broad range of programs to assist low-income families who have dependent children, whether it's through the Child Disability Benefit, the Learning Bonds, the Education Savings Grant, numerous programs that do exist already for families of lesser income. What this bill is about a principle of benefits to seniors. They're supposed to provide with the necessities of life, ensure that seniors themselves have that. Not about their children, about the seniors. And these are individuals for whom it's intended to support.
I'm going to come back in a few.
And in the case of prisoners, they're already receiving those benefits courtesy of the hardworking taxpayers of Canada. That's what it's about. I would suggest that if an individual were that concerned about their family and their family's welfare, that they shouldn't be getting themselves in a situation where they're in prison in the first place.
Thank you very much. We will now go to Mr. Vallacott, please.
Thank you, Madam Chair. To the Minister, thanks for being here. I guess you did, in the course of the previous remarks here, and just recent, in fact, to the member opposite, spoke about the purpose of old age security and the guaranteed income supplement. So I asked rather directly and to the point, just a couple quick questions on that. Is the rehabilitation of criminals one of the purposes of the OAS? I mean that sincerely. And is the purpose of OAS to be a savings plan for prisoners?
In a nutshell, absolutely not. Old age security was designed to help seniors, those people who build our great country, ensure that they have a certain standard of living in their golden years. It's there to make sure that they have a place to live, they can afford that they can afford to put food on the table for themselves. It's to take care of their immediate benefits. It was never designed as a savings plan. It is income tested. Once individuals reach certain plateaus, then the amount of OAS they receive is reduced because they obviously have the ability to meet those basic needs of food and shelter. Prisoners are likewise already receiving those benefits courtesy of the taxpayers. So no, it was never intended as a savings plan, was never intended as a rehabilitation program. Its sole purpose in law is to support the needs of our seniors, to make sure they have an adequate living level.
Right. To summarize that, I mean, we have other programs in place to rehabilitate criminals through Corrections Canada. They have their specific programs for that, but clearly the OAS is not meant for the rehabilitation of criminals.
You're absolutely right.
Thank you.
There are a number of programs, both federal, provincial, and through NGO levels, to assist prisoners with rehabilitation and indeed with reintegration into society once they're released.
Thank you. I'm done with my questions. I'm passing on here.
You have 3 minutes if you want to share, Madam Wong. Mr. Watson.
Thank you, Madam Chair. Minister, thank you for being here. Something interesting has been developing. I don't know if you've been following the hearings on this particular bill to this point, but off the camera, the opposition members have been arguing almost exclusively with their time in favor of prisoners being able to bank their OAS. Interestingly enough, when the cameras are on and Canadians are watching, they're not lining their questions up that way, or they're doing it in a much more subtle way. So, to this point,
that's not a correct statement that Mr. Watson just made.
That's debate, Madam Chair.
No, but it's a lie.
All right, excuse me. I think we want to find out about the bill, so I would just encourage us to stay on.
We should encourage honesty at the committee, because what he said is factually untrue.
Okay, thank you very much for that, Mr. Savage. Mr. Watson, if you could
thank you, Madam Chair.
Try to stay on.
That was debate, I think, Madam Chair. I hope that doesn't detract from my timing. But more to the point here, law-abiding citizens, do they have the opportunity to bank their OAS while the taxpayers pay for food, clothing, shelter, heat, cooling, dental, health care, the way they do for those who are incarcerated?
No, indeed, they do not. In fact, the amount of OAS that they collect is determined by their other forms of income, because if they are totally self-supporting, then they're entitled to either a lot less or some less OAS support. It's designed to provide a certain standard, and beyond that, if a person is receiving that they're, through other sources, no, they're not entitled to it, certainly not to bank it for futures.
Now, in the suspension of OAS benefits until such time as the sentence is served, can you hive off high-profile inmates like Clifford Olson or Robert Picton or Paul Bernardo or Russell Williams from sort of the less-profile inmates and allow them to bank it, the less-profile ones to bank it? Can you hive them off in the suspension of benefits?
No, we have to make sure that the law is applied equally to all, and so we have to make sure that the law does apply.
So in effect, if you're arguing in favor of the opportunity for some inmates to bank their OAS, you're actually arguing in favor of all inmates, including the Pictons and the Bernardos and others, to be able to bank their OAS. Is that correct?
It is, and there comes a question that if you start to say some but not all, how do you choose? If someone murdered once or was convicted of one murder, are they less of a heinous person than someone who was convicted of two? At what point do you draw the line? We believe that the courts and the laws of this land set certain standards for acceptable behavior and certain standards for the punishment when people do not practice the acceptable behavior. If someone is, whatever the crime, has been determined to have been serious enough through our national system and our provincial system, which reflect our citizens' standards, if they have to have broken the law to a degree that they get certain punishment, then that's severe enough to be incarcerated, therefore not entitled to OAS, we believe.
Thank you. Thank you very much. I think we'll have time for one more question before the Minister has to leave. We'll go to Madame Baudin, please.
Thank you very much, Madam Chair. To begin with, thank you, Minister, for being here with us this morning and your officials. I'm very pleased to see that the Chief of Police of Vancouver advocates this bill, and that sometimes the opinion of police chiefs is taken into account by the government for legislative purposes. As you know, in Quebec, and I just want to come back to a question that I had already asked, and I want to ask the Minister. You talked about the support by the provinces and territories, and I would like to know what reception the province of Quebec has provided, in particular the Minister of Public Security. If we know that the inmates currently get the benefits starting in the third month so that they can have a little bit of money to start with when they get out. So I first want to know whether you've had some contact with Quebec and what their opinion is. I sent a letter to the Minister of the Quebec government, and he responded without saying yes or no. The province of Quebec, in the provincial system, is already doing the same thing. So I'm hopeful. Thank you. I will respond to my colleague's comment from across the floor. Yes, obviously, we do want to help these inmates rehabilitate and reintegrate society once they've paid their debt. We want them to get back into society and be integrated. So have you studied the impact of this bill on rehabilitation? There is a specific purpose to this bill, and that is to adjust the system so that it is fair. We want to be fair to taxpayers across Canada. We want to make sure that people who have committed crimes, who have been convicted do not receive money from the taxpayers to provide for their basic necessities when those are already paid for. That is not fair to other Canadians. But once those citizens, those inmates become full-fledged citizens again, we know that in Quebec, the inmates get their benefits until the third month to help them. We heard from people last week, the federal penitentiaries and the corrections people and so on have their views. Have you worked with them? Have you asked those questions? There are a number of support programs for people getting out of prison at the provincial and federal level and provided by other organizations as well. But it is important to recognize that these people will be eligible for OAS as soon as they get out. Well, what about an inmate who gets out after 13 years and gets back out? What support is available to that person? Well, there is a whole series of programs. I mentioned provincial programs. There are a number of others as well. There are groups that help those inmates and are set up to do that. For example, Elizabeth Fry, John Howard Society, and so on, that provide financial resources to them, because we were talking about mechanisms and you did not want to necessarily facilitate the access for these people to their benefits once they are getting out. They have to write a letter to the minister, if I understand correctly. No, we do want to facilitate that access, of course. They can go to Service Canada right away to ask for benefits, and we will expedite the process to provide them with a payment, as I mentioned. So they could get it earlier than 4 weeks, in less than 4 weeks. Yes, and that is why I mentioned it. Because we want to help them right away, but they have to go to Service Canada because we have to check their identity and the information for their bank account and so on. Thank you.
Again, Minister Finley, for being with us today, and we understand that you need to go at this time, but your officials will be staying and will continue the rounds. So thank you for being here, and if the officials are all right with staying, we probably will continue the round and ask you a few more questions. All right? Thank you very much. I'd like to continue with the round as it is scheduled, because that will give the NDP a chance to ask a question as well. And so we'll now go back to the Conservative Party. Mr. Komarnicki, do you have any questions for the officials? All right, go ahead.
Thank you. Once again, thank you for attending, and obviously we've heard from you already in some measure. I know that at least Mr. Cole Martin from the NDP raised the issue of universality of old age security early on in the proceedings. I'm assuming that with the understanding that pensions should not be taken away from prisoners, but as I mentioned to the Minister,
That's a false statement. I've never made that statement that we should not be taking the pensions away.
All right.
My position has been quite clear, Madam Chair, that it's this methodology that's wrong.
Mr. Comartin.
If he makes false statements,
Mr. Comartin, you all have
false statements, I have a right to put that record straight. And
thank you. Excuse me. Thank you. What we'll do is I would just ask that we all refrain from, if there are false statements, obviously we should not be making them. Let's stick to the bill, and then what I would ask is when you'll have a chance in a couple of minutes, and then if you would like to argue, you're certainly allowed to use your time to do that. But could we? Yes, Mr. Savage.
I think that this is important. I think this is the only meeting we've had on this bill that has been in center block and televised, and it seems to me that there are there's a strategy for spreading false information. And because of the uniqueness of that, I think we have to really reiterate that there shouldn't be false statements made at committee. That's all. I mean,
Mr. Savage, I think that what would be important is when you have your chance to speak, that's when you can clarify your position. And if there is any misunderstanding on the point of with different members of the committee, that's your chance to clarify that. So I would ask Mr. Komarnicki to please.
Obviously,
yeah, Mr.
Point of order, Mr. Lessard. It is not at the time that the person gets to speak because we only have 3 or 5 minutes. It isn't the right time to have a point of order. When there is something going wrong in our deliberations, that is when we raise a point of order. Yesterday, twice in the House of Commons, this happened, and today we've had 2 cases of false information. And they are doing this when we have a public meeting. This is not only inappropriate, but it is unfair because this is false.
You're right now in the middle of questioning. There are sometimes different opinions as to what somebody has said and what someone else has said. I'm ruling that this, at this point, is debate. I'm asking that we finish the questions, and when you have a chance to ask a question, you can clarify your position and make it clear. So I would please ask that Mr. Komarnicki continue, and we will continue the time.
The record will speak for itself, and what I say is what I understand it to be. And the issue of universality was raised. That issue was no question. The logical conclusion that can flow from that is that the pension should be paid to everyone, including prisoners. That's not a point of debate. But my point is, what this legislation does is it doesn't suspend the old age security pension indefinitely. The incarcerated person maintains the right to the pension, but the right is suspended for a specific period that ends when the person is released. So there's a difference in there, and it's an important difference. And so given the way the legislation is drafted, does it address the constitutional concerns that those that would raise the issue of universality and have raised them in this committee? Does it address the issue of the constitutionality of this bill?
I'll provide the first part of the answer, and maybe Mr. McComb will answer the second part. The first thing is that for the universality, there are 2 components for the OAS. There's OAS and GIS. GIS is not available to everybody. This is income tested, so it's really targeted to low-income seniors. So on that aspect, there is already a very clear criteria of selection. For the OAS, there are some criteria that are also established, age, legal status, residence in Canada, and so on. And in that specific case, the person would remain eligible, but the payment will be suspended while the person is incarcerated and would be reinstalled. So in other words, when the person will be released, the person will not have to reapply. It's only to restart, in fact, the payment that were suspended. On the constitutionality, I will leave Mr. McComb to comment on this.
We have a mic issue. In terms of what the legislation does, it doesn't take away eligibility for the pension. It's still, the prisoner is still eligible. It's just a matter of suspension during the time period that the prisoner is incarcerated. And the doors open when the prisoner is released to have his pension or her benefits restart. Same thing in terms of eligibility during the time period they are incarcerated. They can apply. They just won't receive them until they're released. So it's completely within the pension system, and it's a measure that's designed to be within the pension system.
Now, on another point, I know Mr. Lessard has raised this point with regard to using Section 78 to accomplish the idea of taking the funds away from the prisoners to allow for the fact that they're getting free room and board basically while they're in prison. But when you look at, when I look at Section 78, it ties into a regulation, as I understand it, Regulation 104 of the Corrections and Conditional Release Regulations, and it has a number of conditions when we talk about income. It talks about essentially, if you want to call it clawing back, 25% of the inmates' total income, but then it has a condition which exceeds a certain amount, and then it goes back and limits what that is. So, number one, it would need to be dealt with in some fashion because it doesn't address it. Would you agree with me? And secondly, the corrections official raised the issue that inmates may not have their old age security or supplement arriving at the prison for that section to be applicable, and they could circumvent it simply by having it deposited elsewhere. Can you comment on those 2 points?
And if you could do it quickly because the time has expired for your questions. Thank you.
Well, I would say that the way you describe the challenges are correct, and when we look at the 78 and compared to the objective we wanted to achieve, that was a very complicated, very limiting tool that they have in their hand at the correctional services, and that's why our conclusion was that what is being proposed is the more direct, efficient, and cleanest way of doing it, and that's why this bill was presented as the best way to achieve the objective we had in mind.
Thank you, Madam Folco. You have 5 minutes.
Thank you, Madam Chair. Je voudrais peut-être revenir.
I would like to come back to the agreement or the questions that the minister raised about sharing with the provinces and territories. Through the minister, we did have an answer, but I know that this is an extremely complex system to understand for the average person. So I would like an explanation from you for the OAS and for the guaranteed income system, specifically for Quebec. How would the information sharing take place between the Quebec government and the federal government? And what is the purpose of sharing this information? Well, it would work the same way as what we are planning to do with correctional services at the federal level. We would have an agreement with the equivalent services in Quebec, and that is what we are proposing to do at the federal level. We would get information from them about any inmate over the age of 65 with enough information to enable us to go into our data banks and to suspend the benefits. Similarly, for those who are being released, we would get that information about people coming or going, and that would allow us to reinstate the benefits for inmates who are being released. As the legislation states, the inmates or former inmates would need to come to a Service Canada office to expedite the payment of the benefits if necessary. Ms. Mina and I asked a question we asked our question of the minister earlier and of Service Canada, rather correctional services officials, regarding payments for dependents, not necessarily those in university, but dependents. To your knowledge, do the provinces and territories have access to that information? Do they know whether inmates have dependents that they might need to support for a long time? Well, I don't know whether they have that information, and that was the answer you got from Correctional Services Canada. Where the spouses are concerned, this information is important for OAS and in particular for the guaranteed income supplement. We need to know whether the inmate is single or is in a relationship because there are consequences for the benefits. And as I have already said, there is no connection between OAS and dependents because the old age security system is aimed at providing support for seniors and meeting their basic needs. So there is really no consequence for that, whether there are independents or not. There are other programs to help in that area. Unfortunately, the minister has had to leave, but I hope she will be able to read the comments that are made here after her departure. And I have had a similar answer to what you have just given. But as my colleagues have said on this side, we agree that there needs to be a bill like this. We will support Bill C-31 and pass it as soon as possible. There's no doubt about that. But we want to know what the financial implications might be on dependents of these inmates. We want to we agree with the principle of punishing the person who has committed the crime, but we want to know to what extent those who are dependent on the inmate are also being punished. And this is the question that Ms. Mina and myself have been trying to explore. Well, there are two aspects, as I have mentioned. We have the old age security that the spouse will continue to receive. There's no doubt about that. Regarding the guaranteed income supplement, which applies to low-income seniors, our intent is to adjust the amount that the spouse would receive. When people are part of a couple, there is a certain calculation done on the basis of the couple's income. In this case, the spouse is not incarcerated, and we will review the calculations based on the spouse's income, and that might mean an increase in the guaranteed income supplement so that there is a minimum negative impact. Thank you.
Thank you, Madam Chair. We've had Section 78 raised a couple of times here. I want to return to that. I'm presumably it's being raised for two purposes. One, I think, is in the notion that costs can be somehow recovered. The cost of incarceration can somehow be covered by Section 78. I think we've heard testimony here that the average cost of incarceration is somewhere between $90,000 and $100,000 per inmate per year. I'm not sure that even at 30% of income that comes to a penitentiary for an inmate is likely going to recover the costs of incarceration. Is that a fair statement as you would understand it?
I think the Commissioner provided some information on this. I'm not the specialist of cost of incarceration. Our main source of information for me would be Statistic Canada on this, but I think that your numbers are most likely close to the reality, yes.
Presumably the implicit extension of arguing that costs can be somehow recovered is that any other incomes could then be banked. I think that's where that's going, but I don't think, Madam Chair, I'm going to pass my time because the witnesses aren't. I can't ask more questions on Section 78. I think for where I want to go with my line of questioning. So if I could defer to Ms. Wong, Dr. Wong.
Thank you, Madam Chair, and thank you, for coming over. Now, I wanted to comment or ask a question about the children of the victims, because just now the opposite raised the question about the children or the junior of the prisoners, But my question is that if what about the children of victims? So do we have social programs helping those families? That's number one. Secondly, I don't know whether everybody is aware of the fact that when Clifford Olson, before he was actually sentenced or actually prosecuted, he claimed $10,000 for each body, the 11 children. He sort of told the police where about they were, and this money went to his family. Now that is history. and that's outrageous. Right now, I'm thinking that this bill only deals with the person himself. And you have explained very clearly that the bill ensures that a low-income spouse or common law partner of a prisoner will not lose their individual entitlement to old age security payments. Can you further comment on this part so that families, of the prisoners actually will not be affected by this?
Yes, I guess for the old age security, the spouse will receive the full entitlement as for any other person that the person is eligible to. And if the person has other revenues, that's something else. If they don't have any other revenues, that's when the supplement, income supplement kicks in, GIS. And so it means that there are no other revenues. And in that case, what I explained is that we would ensure that depending of the income of the person, that they would be calculated on a single rate instead of a couple rate for couples, and that will lead up to an increase most likely of their revenues for the spouse. I'm saying, and that will recognize the condition of the spouse in this specific situation.
For law-abiding citizens, seniors who are receiving OAS now, who have families who need more support, there is also a provision for them. But am I right for that, to say that?
No, for the OAS, as I said a bit earlier, the fact that they are or children or no is not taken into consideration. So if there are needs for children, then there are other federal programs and provincial programs, by the way, but also federal programs to support children in these circumstances. And these will continue, of course, to be available for children. So they are not interrelated to whatever measures we would take in the context of the OAS.
Thank you very much. Mr. Kilmartin?
Well, given some of the exchanges we've had today, let me just make a statement or a comment. What's really going on here is a government that's so obsessed with punishment, and I just was reading one of the quotes of Minister Finley this past spring when she said, referring to prisoners who are eligible for OAS, that they should be getting punishment, not pensions. And it's that mindset, Madam Chair, that is the problem here. If we had taken a much more holistic, taken the Russell Williams case, since we're dealing with individual cases here, Mr. Watson's wrong. If you look at the opportunities we had here for amending both the OAS and the Corrections Act, specifically Section 78, we had the opportunity here to deal meaningfully with claims from victims. Think of those women who were raped by Mr. Williams. Think of the women's families, the women who were killed, those families. We have existing laws which would have, if these funds had been available, and more funds, Mr. Williams' pension, that's $65,000 a year he's eligible for. If that fund was made available, which it's not now, to the victims, then we actually could have compensated them financially for the lost time that they're going to suffer, the family's lost time, for the counseling they're going to need, and other expenses that they incur. We know that victims incur. If this government was really meaningful in wanting to deal with victims, that's one of the ways. They had an opportunity to do it here. Now, are we going to be faced with another piece of legislation at some point down the future? Maybe. So let me just turn to one question. Was there any consideration given, and it's not fair to you probably to ask this question, but I want to get it on the record. I would like to have asked it of the Minister. Was there any consideration given to expanding Section 78 so that, in fact, we could have got at other resources, CPP, OAS, the supplement, but also private pensions and private assets when people were incarcerated, especially with those kind of crimes?
In our discussion with correctional services, what we were, and that was my responsibility, what we were concentrating on was really the case of the OAS and how we can prevent OAS being paid to people that are incarcerated while they are incarcerated. So when we look at 78 and we look at the other means, and with some of the limitation that 78 has as well, our clear conclusion was that that Bill C-31 was the most effective and cleanest way to achieve that objective.
Did you take into account the victims?
I would. That's another question I will come back to. The other issue, and I think that the commissioner, when he was here, raised that issue as well, is that at one point, if you start looking at how correctional services can go after a lot of funds, I mean, his concern was that then you would spend more time trying to collect money than to do his main mandate. And that was.
You just had to make the funds available. You didn't. I don't want Corrections Canada to be turned into a collection agency, but all you needed to do is. I'm sorry. I'm not picking on you.
Sure.
I wish the minister was here so I could pick on her. I wish the Prime Minister was here so I could pick on him. You didn't have to turn Corrections Canada into a collection agency. What you had to do was to make the funds available, not just government funds either, but private assets. An amendment to the Corrections Act would have done that.
I would say that's a much broader debate, and in that context, what we concentrated on was the fact that they were public funds, OAS, that were paid to people that were incarcerated while their basic needs were looked after.
And I don't have any problem, Mr. Paquette. It's a very efficient mechanism for the department and for the government, but it doesn't do anything for the victims. One more comment. Mr. Watson, actually, if you do a calculation, if you'd have made the funds available from Mr. Williams, you would have been able to get up to the 30%. But you also have the right to change that 30% up to 50% or even 100%. Simply would have required an amendment to Section 78 of the Corrections.
Thank you, Mr. Comartin. Just a reminder, please direct comments through me as the chair. Thank you very much. We have time for one more round. It will be a 3-minute round, and so we'll begin with the Liberals, Mr. Savage.
Well, thank you, Chair. I don't normally take 2 rounds, but per your recommendation, I do want to clear the record. There's something happening here. We've had a number of hearings on this bill, and they've been pretty cooperative. We've asked our questions. All of a sudden, we come to center block and we're televised, and we start to get some allegations from the government that need to be corrected. I've corrected one of them already, but the idea Mr. Watson said that the opposition is out talking about the banking of OAS for prisoners, the comment about Mr. Comartin's position, which I think he's cleared up. It's important people understand that this bill could have been dealt with faster. In fact, it was on March the 26th that there were media reports that Clifford Olson was getting a pension. We were all outraged by that. On that same day, the minister made comments in the House saying that she would be bringing forward a bill very quickly. It wasn't until June the 1st that C-31 was introduced for first reading. There's a big gap there, and we had indicated in that time that we supported the intent of C-31. We intended to support the bill. We went further to suggest that in our view that there should be money that is recouped through this bill that should go to victims of crime. I mean, let's not forget that the government has cut the budget of the grants for the Victim of Crime Initiative by 41%, contributions for the Victims of Crime Initiative by 34%. They fired the federal ombudsman for the victims of crime. We think this money should go to the victims of crime. I agree with Dr. Wong when she talks about people who have been harmed by people who are now in prison. So I think it's just important that we understand that the opposition is doing their due diligence on this bill, but we are not stopping it. We are not opposing it. We are just trying to make sure that this bill does what it's intended to do, as we've done from the beginning, and as our critic on this issue, Judy Scrow, has done vigilantly since March the 26th when these reports were made public. That's what I wanted to say, Madam Chair. If I'll have time, I'll give it to again.
1 minute if there is a question from anyone else from the Liberal side.
I'll be very
1 minute.
Okay, I'll be very quick. My question actually, Madam Chair, is very simple. I simply want to ask, this bill makes the assumption that the incarcerated person and the spouse are both old people. My question is very simple. If the spouse is not an old woman, has children, or there is a dependent, a disabled dependent person, will the OAS still be cut, or will it be sent to the family? I'm asking.
There are two situations. If you're saying that the incarcerated spouse is over 65, so therefore receiving OAS, and the non-incarcerated spouse is younger than 60 years old, for example, the OAS of the incarcerated person will be suspended. Yes.
So then the family also loses the income that they would have had and be punished as well. That's the point I'm asking. That's why I had hoped that some due diligence had been done on this bill prior to sending it in. Thank you.
Mr. Komarnicki?
Thank you, Madam Chair. I, too, will make some comments. I know Mr. Cole-Martin has indicated that he would like to even go beyond what this bill is. How about getting behind this singular narrow bill and getting it through real quick? That would be a good thing to do. And I know under the lights, the opposition has taken a milquetoast approach to this, but there were concerns raised about money being there for prisoners in their accounts when they leave prison, as opposed to taking all of the funds away through a bill like this. And that's just fact. And in terms of how long it's taking to get it done, I mean, the Liberal Party had 13 long years to get it done, and this is being done in less than 13 weeks. And I would say let's go clause to clause right now and get it done right here and now while we're
sure, we could have done clause by now.
Ladies and gentlemen, if I could, ladies and gentlemen, Madam Mina, when you're speaking, no one's interrupting you, and it seems like that's been happening. So if you could please refrain from interrupting, that would be great. Thank you.
So let's not try to point the finger one way or the other, and let's move this thing through, because I don't want to let that go uncontested, because it's a bit of bunk. Now, for some specific questions, just to ensure that spouses of inmates aren't harmed by this, you've indicated that. And the corrections officials have indicated there will be a process in place to find out who the spouses are. But when you're dealing with GIS, is it not based on the income of the previous year? And how are you going to collect that information in a relatively short period of time to ensure the adjustments are made quickly and appropriately so that those get into the hands of the people that do need them? If you can maybe address that point.
The OAS programs permit individuals to provide them what was called the option. So rather than waiting for getting data from CRA on the level of income, one can make a declaration and exercise thus the option of indicating that they will have indeed lower income for the current year and have an immediate adjustment to their GIS.
So that would be made within the month following incarceration, and you'd be able to have that information?
Yes.
Okay, and then with respect to the notification of the prisoner's release, is that information going to be able to be obtained by you in a timely fashion, and will you be able to utilize additional information to ascertain the whereabouts or address of the person that's released?
Yes, I mean, and that's the purpose of the information sharing agreement that we will have, is to be able to have access to the appropriate information that we need to be sure that, first of all, we are informed of incarceration or release, and as well as any information required to make sure that we deal with the right person, so identification. And the other information that we need that will be useful, and that's why we ask, in fact, the person that is released to contact Service Canada to give us the banking account, is that if we are able to do a direct deposit, we will be able to accelerate even further the process to allow them to receive their pension. So these are the type of information that we will need to accelerate the process.
So,
Mr. Lessard, you have 3 minutes.
Merci, Madame la Présidente.
Thank you, Madam Chair. Thank you for your last answer, Mr. Paquette, because we have tried to get that confirmation, and you gave it to Ms. Mina. That is, there is the recognition that if the inmate has a spouse under the age of 60 or 50 with dependent children, that person will not get any income, any old age security. And one of our concerns is to make sure that this bill does not create any victims And this is a concern that I think is not reflected here. We feel that what we're hearing is that inmates need to be punished. We feel that they should contribute to their lodging and so on. That is fine. But we find that there is no concern to support the victims. Not only that, but there is a risk here that we may create victims, and those will be the dependents, as Ms. Mina mentioned. This surprises me. There seem to be no statistics showing how many dependent children may be affected by this new provision. I understand that you might not have provincial inmate statistics, but why don't you have any information on federal inmates? You have information, you have files on them, you know the color of their underwear, so you know everything. Why is it that you don't know whether there are dependents, how old they may be? They may not be young children, they may be dependents because they are disabled and so on. We don't see any concern about creating possible victims and punishing them. And that is the problem with this legislation. In the work that we have ahead of us, we need to find ways, and I think you can help us with that. We need to make adjustments without compromising the objective of the bill. I hope that's clear. Yes, I have 2 points to make. First of all, dealing with this specific case of dependence and so on, I think we are moving away from the purpose of the bill. I think we are taking 2 aspects and drawing a wrong conclusion. Old age security was created to meet the basic needs of the elderly, of seniors, and it is not a family support program. There are other programs for that. So you talked about a mother with children and so on. There are other programs that exist and will continue to exist for that purpose. Old age security is intended only to meet the immediate needs of seniors and provide them with their basic needs. Well, perhaps I will say something that will help you to give a more specific answer. If somebody earns a salary, the number of children is not taken into account. The same thing for this benefit. It is not based on the number of children. So when my colleague asked the question about measures to support those children, the minister was not able to identify them. Could you do that? The minister did mention certain federal programs that support children, and there are provincial programs. She gave specific examples, for example, for children with disabilities and so on. The government's concern to help children has resulted in programs for that purpose, and we will continue to provide those programs, but the OAS has never been intended to do that. It is really specifically meant to help seniors. So the government will continue to see to the needs of children and families, but not through this measure. Thank you, Mr. Lessard.
I want to thank the witnesses for being here. I understand that we've had a great opportunity, and we've all asked you the questions that we have around the table. So once again, thank you very much for being here, and we'd like to dismiss you at this time, and this meeting is adjourned. Thank you.
Of us may still have questions.
And everyone was done. So if you had more questions, I guess we'd have to determine if we're going to allow you to just continue or you know, how the committee wanted to continue, because we did actually complete the round. So we are actually done this round as we had agreed to, and we were not going to begin a second round. And obviously, we weren't just going to, you know, have you continue unendedly with questions. So that was why we completed the round. Mr. Comartin didn't have any other questions. The government didn't have.
I have two more questions.
Well, this is what I'm saying. If we're going to begin, we don't have time for a fourth round. This was our third round. I gave everyone an opportunity to ask questions, and you had your allotted time. Actually, you had quite a bit more than your allotted time, but I wanted, because I knew that you wanted to finish this and we didn't have other questions. So everyone had a chance.
If I may, I would like to ask another question.
We're going to do a fourth round, and we didn't have time for a fourth round. So that was why I had already adjourned the meeting, because I did ask everyone if they had a question. Mr. Comartin?
I note you did adjourn the meeting. I thought from the previous discussion we had at the start of the meeting, we were going to spend at least a few minutes on how we're going to go to clause by clause, or what we're going to do next on this bill. I thought maybe we would go into camera and just do some quick business.
Sure. You know, I thought we would just discuss that, but if we'd like to do that as a committee, I would be fine with that. Let's, I did adjourn, so just one moment. I did adjourn, so if it's the will of the committee, we can reconvene right away for just a couple of moments in camera so that we can have the discussion. Or, Mr. Comartin, if it would be satisfactory with you, we could have that discussion. I think we had agreed at another meeting that if you did have witnesses, that we could bring those witnesses forward on Monday before we do clause by clause. So I think that would satisfy, and it doesn't look like we have the will of the committee to...
I just enjoy the companionship of the committee, Madam Speaker. Madam Chair, that I thought everybody would want to partake in the discussion.
In the discussion.
That's fine. I'll discuss it with you.
Okay, I adjourned already. Yes, of course. So, and the meeting is now adjourned. Thank you.